In domestic violence cases, there are three big mistakes that guilty people don't make, but innocent people often do. Before your first court date, there is a possibility of getting the charges dropped, but innocent people, unfortunately, often fall into these traps that guilty people are able to avoid that make their cases much worse from the very beginning. My name is Veronica. I'm a domestic violence defense attorney representing clients throughout the entire state of California, helping them put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to represent yourself in a restraining order hearing and win. So if that is something that you need help with in addition to this criminal case, this arrest, make sure that you get your free first class via the link down below. Okay, so let's jump right in. The three big mistakes, the three traps that innocent people fall into that guilty people, knowing that they are guilty, are able to avoid that can make your domestic violence criminal case so much worse from the very beginning. Trap number one: contacting the police, encouraging the victim to contact the police after the arrest. So if the victim is on your side, if they even bonded you out, that is not unusual. That is what happens in a lot of cases. But this is all new for you. And so you may be thinking, and the victim may be thinking, okay, let me contact the police. Let me contact the DA and just explain that as the victim, I lied, or it was a big misunderstanding, and try to get rid of this case. And you'll find out quickly, if you haven't already, that the victim cannot drop the charges, but it may seem like, okay, but the victim should have some power over this. And so contacting the police, telling them you want this dropped, giving more and more statements that this could be helpful, but this often severely backfires. Look, if the police make an arrest, their goal in writing up their report is to justify the arrest. The criminal justice system, at least in the state of California, does not care what the victim wants. And once you're arrested, you are looked at as the perpetrator. You are looked at as somebody who did something wrong here. The victim seems too eager to get charges dropped. They must be being coerced by you, the defendant, the abuser. The police call, you answer the phone, you give a statement, and some slight detail is different than what you said initially. Okay, you're lying. It couldn't be that there was some mistake there, or they didn't ask you about whatever you said the first time. The victim says, I started all of this. I'm the one who attacked the defendant first. Okay, so now the victim is acknowledging that a physical altercation happened. Whatever you and the victim say, they are going to twist. Number two, refuse to take proactive steps advised by an attorney. So if you hire an attorney before your first court date, which you should, and I'll get into a little bit more as to why in number three, your attorney should be telling you different things that you need to do. Some of those things may be going to therapy. They may be going to domestic violence classes. It's on a case-by-case basis. If you're a guilty person and you know that you did something wrong, you might think, yeah, you know what, that was messed up. I made a mistake there. And maybe you don't really mind taking those classes. But sometimes what innocent people think is, no, that's an admission of guilt, or no, why should I have to take those classes? I did nothing wrong, or I was the victim and the police just arrested me. It is not taken as an admission of guilt. Instead, the justice system views this as a CYA for them, and it also views you taking these steps as you being someone who is not going to end up in this situation again. If this is your first arrest for something like this, you're taking this seriously, and you at least want to make sure that you never end up arrested again. That's what they want to see. And the earlier that you start this, the more that it can be used in your favor. And I didn't list this as a separate step, but some attorneys will not advise you to take any proactive steps. That's a big mistake. You do need to be proactive in these domestic violence cases. That is not necessarily true for every type of criminal case. So sometimes attorneys who take every single type of criminal case that walks in the door, gang crimes, murder, whatever, you're not advising those clients to take domestic violence classes, right? There's no point, plus they're also in jail. So if they are not on top of this and giving you those proactive steps to take, that is also a problem. So if that happens, you should talk to them about it and make sure that you do get those instructions. Number three, wait for your day in court. So after your arrest, you have a court date coming up, maybe in a few weeks, maybe in a few months. Innocent people will sometimes make the mistake of waiting for their day in court to explain their side of the story and or to see what happens and see if charges are filed against them. Okay, so I'm going to address the first part first, waiting for your day in court. At that first court date, you are not going to have a chance to explain your side of the story. For the most part, at that first court date, not a whole lot happens. There's no time and there's no opportunity for anyone to explain your side of the story to the judge. And even if your attorney did explain it to the judge anyway, the judge has no ability to dismiss the case that day anyhow. Okay, the second reason why innocent people might wait for their first day in court is because they've watched some videos, and I've posted many videos about this, that explain that there's a possibility that the prosecution will decide not to file charges, that they will look at the police report, they will look at your criminal history or lack thereof, and they will decide not to file charges. Now, some of the thinking here is, I'll just see if this is a problem that I have to do something about, if I have to hire an attorney, take classes, I'll just wait and see if there is actually a case filed before I do anything. If the DA files charges against you, that means that you have lost that opportunity to have an attorney contact the DA before court and try to persuade them not to file charges against you. Before court, there is a prosecutor who's looking at a stack of police reports and anything else in the file, deciding whether to file more serious charges than what you were arrested for, less serious charges, go along with whatever you were arrested for in the first place, felony domestic violence, for example, or drop the case altogether. So that's their job, decide what to do. Once your case gets to court and charges are filed against you, now there's a prosecutor whose job it is when they go into work in the morning is to prosecute you. The chances of an outright dismissal drop significantly if charges are filed against you. So it is very important to do everything in your power in that limited time that you have between your arrest and your first court date to try to get the case dropped. It might seem like it will be easier to just wait for that date and not deal with anything until then, but it will potentially make your case much harder and drag everything out for a much longer period of time and make everything much more expensive than it ever would have been if you had taken action before court. I hope you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation there. And if you did find it helpful, please don't forget to like, subscribe, ring the bell, and if you have a question, leave it in a comment.